My name is Eleanor Grace Whitfield. And this is the story of how my own brother stole everything my father built, and how I made them pay for every single dollar. There are houses that hold memories the way old wood holds smoke. Long after the fire is gone, the smell stays. Our house on Maple Creek Road in Cloverdale, Virginia was like that. A two-story colonial with white shutters and a wraparound porch where my father used to drink his morning coffee before the sun fully rose. He said he liked to greet the day before it got too loud. That was my father, a man who believed in quiet moments and honest work. His name was Robert James Whitfield. He was a contractor. He built things with his hands, decks, additions, custom homes for people who had more money than he ever would. But he saved. Lord, did he save. Every dollar he didn't spend on us, he folded into that property on Maple Creek Road, into the commercial lot he owned on Route 9 near the county line, and into a small rental house on Dundee Street that he bought in 1987 for $42,000, and that, by the time he died, was worth nearly $400,000. He worked 31 years for those 3 properties. 31 years of early mornings and sore backs and coming home with sawdust in his hair. He used to say, "Eleanor, a man's land is his word made permanent. You can lie about money. You can hide money. But land doesn't lie." I was 23 when he said that to me for the last time. He died 11 days later. My father had a massive heart attack on a Tuesday morning in October 2007. He was 58 years old. He was in the driveway of a client's home in Staunton when it happened. The paramedics said he was gone before the ambulance arrived. I got the call at my apartment in Richmond, where I was finishing my undergraduate degree. My brother Marcus called me. He was crying, or at least, that's what it sounded like. Now, looking back, I think he was performing. Marcus was always performing. I drove home in 2 hours and 40 minutes. I remember every mile of that drive. The way the October trees looked all orange and rust and dying, felt like the world was already in mourning. My mother, Patricia Whitfield, was sitting at the kitchen table when I walked in. She looked like someone had removed something essential from inside her. Not just grief. Absence. My brothers were already there. Marcus, the oldest at 31, sat at the head of the table, my father's chair, with his hands folded in front of him like a man at a business meeting. My other brother, Dennis, 38 and long since moved to Roanoke, stood by the window with his arms crossed. He didn't hug me when I came in. He nodded, like I was a colleague he'd met at a conference once. I should have known then. But grief makes you blind. It narrows your world down to one raw feeling, and you stop noticing the small things, the way Marcus kept glancing at Dennis, the way Dennis kept checking his phone, the way neither of them cried. Not really. Not the way my mother and I did. We buried my father on a Saturday. The church was full. He had built half the porches in Cloverdale, and every family he'd ever worked for showed up. That's the kind of man he was. Not rich. Not powerful. But real. After the service, after the food and the condolences and the slow clearing of the house, Marcus sat my mother down at that same kitchen table and said, very calmly, "Mom, we need to talk about Dad's estate." I was in the hallway. I heard everything. My father did not have a formal will. This was the crack in the wall that my brothers had been waiting for. He had spoken about his wishes many times to my mother, to me, to his friends. Everything was to go to my mother. Simple, clear, undisputed. But without a written will, the state of Virginia required the estate to go through probate. And in probate, all heirs, meaning all 3 children, had legal standing. Marcus and Dennis had already spoken to a lawyer. Not a family lawyer. Their lawyer. Within 3 weeks of my father's death, they had filed paperwork claiming co-ownership of the Dundee Street rental property on the basis of an alleged verbal agreement with my father that he had promised it to them for their contributions to the family business. There were no contributions. Dennis hadn't worked a day with my father since 1999. Marcus had helped on 2 jobs in 2003 and had been paid cash for both. But the paperwork was filed. And it had signatures on it. Including mine. I did not sign those documents. When I confronted Marcus about it, standing in the kitchen of the house on Maple Creek Road 3 weeks after our father's funeral, he looked at me with the flattest eyes I had ever seen on a human being and said, "You signed it, Eleanor. I watched you." I was 23 years old. I was grieving. I didn't yet know the name for what he had done. I didn't yet understand that my own brother had committed forgery. I just knew, in the deepest part of me, that something had been taken. It would take me 7 years to understand exactly how much. They didn't take everything at once. That's the cruelest part of what my brothers did. It wasn't a single violent act. It was a slow erosion, the way water wears down stone, patient, methodical, invisible until the damage is already done. First came the rental property on Dundee Street. Through the forged document and the probate proceedings, Marcus and Dennis managed to have it transferred into a joint LLC they had formed, with my mother listed as a passive partner with no voting rights. My mother, who had never dealt with legal or financial documents in her life, signed what they put in front of her because they told her it was for tax purposes. Because they were her sons. Because she was a 61-year-old widow who trusted the people who had grown inside her body. I was in Richmond. I was finishing my degree. I was calling home twice a week and being told everything was being handled. Then came the commercial lot on Route 9. A developer had approached my brothers, not my mother, my brothers, about purchasing the property. The lot had been appraised at $340,000. My brothers sold it for $290,000, the difference going into administrative and legal fees associated with the estate, fees I later discovered were billed to an LLC that Marcus himself owned. My mother received a check for $40,000 and was told the rest had been absorbed by debt my father had apparently owed. Debt that, when I eventually dug into the records, did not exist. And then, finally, the house. The house on Maple Creek Road. My mother lived there for 2 more years after my father died. She paid her own bills. She maintained the property. She thought it was hers because it was hers. Her name was on the original mortgage alongside my father's. But Marcus had spent those 2 years quietly, systematically building a legal case that the property had been jointly managed by him and Dennis during my father's illness. A fiction constructed from a handful of receipts for yard work and a repair bill that Dennis had paid once in 2006. In December 2009, my mother received a legal notice informing her that her sons had filed a partition action, a legal maneuver that forces the sale of jointly owned property when co-owners cannot agree on its use. She called me crying. She didn't understand the paperwork. She just kept saying, "Eleanor, they want to sell the house. They want to sell Daddy's house." I drove home that night. I sat with her at that kitchen table, my father's table, and I read every document. And somewhere in the reading, something inside me stopped being a grieving daughter and started becoming something else. Something cold. Something focused. Something that understood, for the first time, that love was not going to fix this. Only law was going to fix this. I was 25 years old when I decided to become a lawyer. I know how that sounds. I know it sounds like something from a movie, The Wronged Daughter, The Stolen Inheritance, The Righteous Turn Toward Justice. But it wasn't cinematic. It was practical. It was desperate. It was the only weapon I could see from where I was standing. I couldn't afford to hire an attorney to fight Marcus and Dennis, not a good one. Not the kind who could match the firm they'd already retained. My mother had $40,000 and a mortgage on a house she was about to lose. I had a communications degree from Virginia Commonwealth University and a part-time job at a marketing agency that paid me $28,000 a year. What I had that they didn't have was time. And anger. Specifically the kind of anger that doesn't burn hot and fast and destructive, the kind that burns slow, like coal. The kind that generates heat for years. I enrolled in LSAT prep classes in January 2010. I studied every morning from 5 to 7 before work. I studied every weekend. I scored a 168 on my first official exam. I applied to law school in the fall of 2010. But before I left, before I packed my apartment and drove toward the future I was building on the bones of their betrayal, I did one thing. I went to the Cloverdale County Clerk's office and I requested copies of every property record, every deed transfer, every filing associated with my father's estate. I paid $12 in copying fees. I took the documents home, sat at the kitchen table where my father used to drink his coffee, and I began to read. The forgery was right there. Page 14 of the Dundee Street partition filing, a signature in my name. Dated October 29, 2007, 11 days after my father died, 3 days before I had even returned home from Richmond. I had been in Richmond on October 29, 2007. I had a receipt from a gas station on I-64. I had a text message from my roommate. I had a work shift record. I photographed page 14 with my phone. I made 3 copies. I put one in a safety deposit box at the First National Bank of Cloverdale. I mailed one to myself, sealed and certified. I kept one in a folder labeled simply when, not if. When. I attended the University of Richmond School of Law on a partial scholarship that I supplemented with loans, a part-time job at a Richmond legal aid clinic, and the ferocious energy of someone who has something to prove not to the world, but to herself. My mother lost the house in March 2011. Marcus and Dennis forced the sale through the partition action. The property sold for $260,000. After expenses, my mother received $63,000. She moved into a 2-bedroom apartment in Harrisonburg and took a part-time job at a grocery store at 63 years old. I could not stop that from happening in time. I was not yet a lawyer. I was not yet equipped. And this failure, this specific, concrete failure, is something I carried with me through every class, every exam, every late night in the library when I wanted to quit. I didn't quit. I graduated in May 2014. Third in my class. I passed the Virginia bar on my first attempt. I joined a mid-size litigation firm in Richmond, Hawthorne, Bell and Associates, that specialized in civil litigation and estate disputes. I was deliberate about this. I did not join a big corporate firm. I didn't want to spend my first years drafting merger documents. I wanted to learn how to fight people like my brothers in a courtroom. So I spent 2 years at Hawthorne Bell doing exactly that, learning how courts handle fraudulent transfers, how they treat forged documents, how forensic document examiners are qualified as expert witnesses, how statute of limitations laws work in Virginia for fraud and forgery claims. I was building a case. I had been building it for 7 years. And in the fall of 2016, I decided it was ready. Before I filed anything, I went home to Harrisonburg. My mother was smaller than I remembered. Not in the physical sense, she was still the same woman who had raised 3 children and kept a house and fed half the neighborhood during church fundraisers. But something about living in that apartment, about working the register at a grocery store after 40 years of being in her own home, had pressed something down in her. I sat with her on her small balcony, and I told her what I had. She was quiet for a long time. The kind of quiet that holds more emotion than any words could carry. Then she said, "Eleanor, are you sure?" Not, "Are you sure they did it?" She knew they did it. She had always known. "Are you sure you want to do this to your family?" I took her hand. I said, "Mama, they did this to our family. I'm just going to make sure it's on record." She squeezed my hand. She didn't say yes. She didn't say no. She looked out at the parking lot of her apartment complex, at the place she lived instead of the house on Maple Creek Road, and something in her eyes went very still. That was enough for me. I drove back to Richmond. I sat down at my desk. And I began to write the complaint. They thought I had moved on. They thought the quiet meant I had accepted what they did. They didn't understand that some women don't make noise when they're coming. They just arrive. There is a particular kind of satisfaction in sitting down to write a legal complaint when you have spent 9 years preparing for it. It is not the satisfaction of anger released, it is something quieter than that. More precise. It is the satisfaction of a surgeon who has studied the anatomy for years and finally picks up the scalpel. The complaint I drafted against Marcus Allen Whitfield and Dennis Ray Whitfield was 47 pages long. It alleged, in careful, documented, citation-supported detail, the following: 1. Forgery of my signature on the October 29, 2007 partition agreement relating to the Dundee Street property, at a time when I was demonstrably not present in Cloverdale, Virginia. 2. Fraudulent misrepresentation to Patricia and Whitfield, my mother, regarding the nature and purpose of multiple legal documents she was induced to sign between October 2007 and February 2010, including the LLC formation documents, the Route 9 sale authorization, and the Maple Creek Road partition proceedings. 3. Breach of fiduciary duty, as both Marcus and Dennis had voluntarily assumed management roles over my mother's estate and financial affairs, establishing a legal duty of care which they systematically violated. 4. Unjust enrichment, in the amount of the full assessed value of all 3 properties minus legitimate costs, a figure my forensic accountant placed at approximately $712,000. Factoring in appreciation over the 9 years since my father's death. 5. Civil conspiracy, as the pattern of conduct across multiple transactions and a span of nearly 3 years demonstrated a coordinated, intentional scheme rather than isolated errors of judgment. I did not file it immediately. I had it reviewed by 2 colleagues at Hawthorne Bell whose opinions I trusted. I had it reviewed by a forensic document examiner, a Dr. Patricia Osei, who I had worked with on 2 previous estate fraud cases and who had agreed to serve as my expert witness. I had it reviewed, quietly, by a professor at my law school who specialized in civil RICO claims, because I wanted to understand whether federal charges were also viable. They were. But I decided to begin in state court. Cleaner. More direct. And, frankly, more visible to the people in Cloverdale who had known my father. I filed the complaint in the Circuit Court of Cloverdale County on November 4, 2016, 9 years, 25 days after my father died. I filed it on my lunch break. I ate a sandwich at my desk afterward. I did not celebrate. There was nothing to celebrate yet. The work was just beginning. Marcus found out first. He called me 3 days after the summons was delivered to his home in Riederichsburg, where he lived in a 4-bedroom house that I had always privately suspected was funded, at least in part, by what he had stolen from our family. "What the hell is this?" were the first words out of his mouth. I said, "It's a civil complaint, Marcus. The document explains everything quite clearly. I'd recommend you retain counsel. You're suing your own brothers? Are you out of your mind? What is wrong with you? Do you know what this is going to do to Mom?" I had rehearsed this moment. Not the words, I hadn't scripted it. But I had prepared for the emotional manipulation. I had known, with absolute certainty, that the first thing Marcus would do when served was try to make me feel like the aggressor. Like I was the one destroying the family. I said, "Marcus, you forged my signature. You stole our mother's home. You left her working a grocery store register at 63. I know what this is going to do to you. That's the point." He was quiet for 4 seconds. I counted. Then he said, "You'll never win this." I said, "I'll see you in court." And I hung up. Dennis didn't call me at all. He had his attorney send a letter within a week, a boilerplate response requesting an extension of time to answer the complaint, which is standard procedure. His attorney was a man named Glenn Hobart out of Roanoke. Competent, but not exceptional. I had researched him before I filed. The extension was granted. The clock began to run. If a trial is a battle, then discovery is the intelligence war that precedes it. It is the phase where each side demands documents, records, depositions, where every hidden thing gets dragged into the fluorescent light of legal obligation. I had been preparing for discovery for years. Within 30 days of filing, I issued discovery requests to both brothers that covered every financial record, every communication, every document associated with my father's estate from October 2007 forward. I subpoenaed their bank records. I subpoenaed the records of the LLC Marcus had formed to absorb the estate administration fees. I subpoenaed the real estate company that had handled the Route 9 sale. What came back was more damning than I had even anticipated. The LLC that Marcus claimed had handled estate administration, Whitfield Property Management LLC, formed in November 2007, just 6 weeks after my father's death, had invoiced my mother's estate for $148,000 in management and consulting fees over a 3-year period. The invoices were on LLC letterhead. The LLC had one member, Marcus Allen Whitfield. The invoices were paid from the estate account into a personal checking account that Marcus controlled. The Route 9 commercial lot had been sold to a developer named Carson Realty Group. The difference between the appraised value and the sale price, $50,000, had been paid as a referral fee to an entity called CRG Consulting. CRG Consulting's registered agent was Dennis Ray Whitfield. They had been skimming from both ends. When I laid it all out on a whiteboard in my office, the dates, the amounts, the entities, the transfers, it didn't look like a family dispute anymore. It looked like a conspiracy. A small, domestic, entirely vicious conspiracy conducted against a grieving widow by the two people on earth most obligated to protect her. My forensic accountant revised his damages estimate upward to $940,000. I requested a meeting with both brothers' counsel to discuss potential settlement. They declined. Fine. I deposed Marcus on a Thursday morning in February 2017. In a conference room at Hawthorne Bell's Richmond office. He came with Glenn Hobart and a second attorney I didn't recognize, a younger man who had the carefully neutral expression of someone who had been briefed that this was going to be unpleasant. Marcus had aged. He was 41 now, heavier than I remembered, with the careful, surface-level ease of a man who had spent years performing confidence. He walked into the room and looked at me with an expression designed to communicate that this was all very tedious and beneath him. I let him feel that way for the first 20 minutes. I asked background questions, his employment history, his relationship with my father, the timeline of events after the death. Standard, non-threatening. I watched him relax. Then I put page 14 of the Dundee Street partition filing in front of him. I said, "Mr. Whitfield, can you identify the signature on this document?" He looked at it. He said, "That's Eleanor Whitfield's signature." I said, "And you witnessed this signature being signed?" He said, "Yes. I was present when Eleanor signed this document." I said, "What date was this document signed?" He said, "October 29, 2007. I said, "And where did this signing take place?" He said, "At the family home. In Cloverdale." I let a moment of silence sit in the room. Then I placed 3 documents in front of him, side by side. The first was a dated receipt from a Sheetz gas station on Interstate 64, 30 miles east of Richmond, time-stamped 7:42 a.m. on October 29, 2007, the morning of the alleged signing, made out on a credit card registered in my name. The second was a time clock record from my part-time job at a Richmond copy center, showing me clocked in at 9:15 a.m. on October 29, 2007. The third was a sworn affidavit from my former roommate, Jasmine Carver, stating that she had spoken to me by phone at 8 p.m. on the evening of October 29, 2007, and that I had been in Richmond for the entire day. I said, "Mr. Whitfield, I'd like to give you an opportunity to reconsider your previous answer." Glenn Hobart said, "I'd like a 10-minute recess." I said, "Of course." They took 20 minutes. When Marcus came back, he said the signature had been signed sometime around that period, and that he may have misremembered the specific date. I said, no further questions on this line. We'll continue. I deposed him for 4 more hours. By the end, his voice had lost its surface ease. He looked like what he was, a man who had built a house of lies on a foundation of grief, and who was now watching a woman he had underestimated pull it apart board by board. They came to the table in April 2017. Marcus's attorney called mine and proposed a settlement conference. I agreed. We met in a neutral location, a conference room at a downtown Richmond law firm neither side was affiliated with. They offered $200,000. Split between my mother and me. I looked across the table at Glenn Hobart, and I said, very quietly, no. He said they could go to $250,000. I said, we're seeking $940,000 in compensatory damages, plus punitive damages, plus attorney's fees. If you'd like to discuss a number in that range, I'm available. Marcus was not in the room. Neither was Dennis. Just their lawyers, doing the clean work of trying to make the dirty thing go away cheaply. Hobart said, Ms. Whitfield, you understand that litigation is expensive and uncertain. A bird in hand, I said, Mr. Hobart, I am the bird. And I've been in the hand before. I know what it feels like. This time I came back with a cage. He blinked. The younger attorney wrote something in his notepad. We broke without agreement. The trial of Whitfield versus Whitfield began on September 11, 2017, in the Circuit Court of Cloverdale County. I had requested the venue specifically. I wanted it in Cloverdale. I wanted the people who had known my father to be able to walk past the courthouse. My lead attorney of record was my colleague Margaret Thurston from Hawthorne Bell, because Virginia's rules of professional conduct restrict attorneys from serving as both counsel and witness in the same case, and I intended to testify. I had prepared Margaret's examination of me myself, then handed it to her and stepped back. Dr. Patricia Osei testified for 2 days about the forensic analysis of my allegedly forged signature. She compared the signature on page 14 of the Dundee Street filing with 14 authenticated samples of my actual handwriting, and she testified clearly, methodically, without any showmanship, that the signatures did not match in 7 distinct measurable characteristics, and that in her expert opinion the signature had been produced by someone other than me. Our forensic accountant, Thomas Del Rey, testified for a full day about the money trail, the LLC invoices, the referral fee to CRG Consulting, the gap between appraised values and actual sale prices. He had a gift for presenting complex financial information in language that 12 jurors without accounting degrees could follow. By the time he was done, you could see it on the jurors' faces, not outrage exactly, but something more settled than that. Comprehension. The specific comprehension of people who now understood, clearly and completely, that they had been shown something real. I testified on day 4. Margaret asked me to describe the morning I found out my father had died. I described it. She asked me to describe what I heard in the hallway when Marcus sat my mother down after the funeral. I described it. She asked me to describe the moment I saw page 14 of the Dundee Street filing for the first time. I said I felt 2 things simultaneously. I felt a grief I can't fully explain, because it confirmed something I had been hoping wasn't true about my brothers. And I felt a clarity that I had never felt before in my life. I knew what I was going to do. I knew it was going to take a long time. And I knew I was going to do it anyway. She asked me why I became a lawyer. I said, because my father believed that land doesn't lie. He was right. Documents don't lie either, if you know how to read them. I learned how to read them. Marcus testified on day 6. His attorney had coached him well. He was calm, measured, full of alternate explanations and plausible ambiguities. But on cross-examination, Margaret walked him through every inconsistency in his deposition testimony, every document he could not explain, Every number that didn't add up. She didn't raise her voice once. She didn't need to. The documents were louder than anything either of them could have said. The jury deliberated for 2.5 days. On the afternoon of September 22, 2017, the jury returned a verdict in favor of Patricia Ann Whitfield and Eleanor Grace Whitfield. Compensatory damages, $880,000. Punitive damages, $220,000. Total, $1,100,000. I was sitting at the plaintiff's table when the foreperson read the numbers. I had told myself, before the trial began, that I would not cry in that courtroom. That was not what this was for. This was not a place for tears, it was a place for law, for evidence, for the slow, stubborn machinery of justice that I had spent a decade learning to operate. I did not cry. I reached under the table and found my mother's hand. She had been sitting behind the bar in the gallery. She had been there every day of the trial. I had looked at her when I was testifying, briefly, and she had looked back at me with an expression that I will spend the rest of my life trying to find the right word for. She squeezed my hand. I squeezed back. The judgment was appealed. I had expected that. Marcus and Dennis hired a more expensive appellate firm and spent 8 months arguing procedural errors and evidentiary challenges. The Virginia Court of Appeals upheld the verdict in full in June 2018. Marcus filed for Chapter 7 bankruptcy 3 months later. It was a strategic bankruptcy, an attempt to discharge the judgment. I had anticipated this too. Under federal law, debts arising from fraud and willful misconduct are not dischargeable in bankruptcy. I filed the appropriate motions in the bankruptcy court. The discharge was denied. It took another 2 years of asset tracing, garnishment proceedings, and negotiation to collect the full judgment. But we collected it. Every dollar. My mother received enough to buy a small house, a real house, not an apartment, in the same county where she had lived her whole life. It is a 3-bedroom on a 1/4 acre. It has a front porch. Not the wraparound porch of Maple Creek Road, but a porch. She drinks her morning coffee there. She told me once, about a year after she moved in, that sometimes in the early morning she can almost hear my father. Not words. Just a presence. Like the feeling of someone standing next to you in a quiet room. I think about that when the days get hard. People ask me sometimes whether I feel like I won. I tell them the truth. I feel like I finished something. Winning would have meant my father didn't die at 58. Winning would have meant my mother never lost her home. Winning would have meant my brothers were the people they were supposed to be, the people she raised them to be, the people he worked 31 years to provide for. Winning would have meant none of this was necessary. But I didn't win. I corrected. There is a difference. What I want every woman who hears this story to understand is simple. Grief is not weakness. Grief is the beginning. What you do after grief, that is what defines you. I chose, when I was 25 years old and sitting at my father's table in a house that was being taken from my mother, to do something with the grief that I could hold in my hands. Something measurable. Something real. I chose law. You might choose something else. A camera. A company. A conversation that changes someone's mind. The tool is yours to pick. But pick one. Because the people who wrong us, the ones who look at our grief and see an opportunity, who take advantage of trust and love and the vulnerability of loss, they are counting on us to stay broken. They are counting on us to be too sad, too tired, too unsure to fight back. They counted wrong. My name is Eleanor Grace Whitfield. My father built things with his hands and left them for us. My brothers tried to take what he built. I am my father's daughter. I built something too. And this time, I put my name on every page. The jury came back on a Friday afternoon. $1,100,000. I didn't scream. I didn't cry. I just reached under that table and found my mother's hand, the same hand that used to braid my hair, that used to pack my lunch, that used to sign papers my brothers put in front of her because she trusted them. I held it. And for the first time in 10 years, she exhaled. My brothers thought grief would keep me quiet. They thought a 23-year-old girl with nothing but a broken family and a folder of documents would eventually just let it go. They didn't know me. My father used to say, "Land doesn't lie. Neither do courtroom records." They took everything. The house, the land, the money, and 10 years of my mother's peace. I gave it back. Every single dollar. My name is Eleanor Grace Whitfield. And justice, real justice, doesn't always come fast. But when it comes with paperwork. If this story hit you the way it hit me, you're already in the right place. This is Justice Served Tales, where real stories of betrayal, resilience, and justice don't get buried. Subscribe right now. Hit that bell. Because every week, we bring you another story of someone who refused to stay down. Eleanor didn't give up. Neither do we. Justice Served Tales, subscribe and stay with us.